Good day, my name is Unonza Liseko Manzana. I am Nonza, your relationships coach, still on the subject of creating a better relationship with your money. And today we are going to take a closer look onto your will and your deceased estate tax implications. It's important when you are in a journey of creating wealth to make sure that you also have a will that is put in place. This is to safeguard whatever you have accumulated and to also make sure that when you pass away, your assets and your property is actually distributed fairly according to your wishes among your loved ones. So now, a definition of a will. A will is a legal document that expresses the wishes of a testator on how they would like for their property or their estate to be distributed when they pass away. Now, when you are drafting your will, there are three most important aspects that you need to look into. Your will must be valid, your will must be feasible, and lastly, your will must be accessible. On the validity of the will, your will must be the latest. There cannot be any other will that exists after that particular one. It must be dated, it must be signed, and it must also have at least two witnesses who are signing the will. Now, the witnesses are not witnessing to the actual contents of the will, but they are witnessing to the existence of the will, meaning they don't have to know what is inside the will. They don't have to know the contents of the will. And a witness cannot also be listed as a beneficiary on the will. So you cannot take somebody who is listed as a beneficiary on your will and put him as your witness. And we can even, now it has become necessary to also obtain the contact information of your witnesses. This is to make sure that upon presentation of your will, if there happen to be maybe family members who are objecting the will, then we can just easily contact your witnesses so that they can come and testify. If there happen to be amendments that are made to the actual will, make sure that those amended areas are signed and also witnessed or signed by the witnesses. On the feasibility of the will, really we are checking here to see if there is enough on the estate to actually satisfy or meet the wishes of the testator. Remember, in order for a will to be executed, it has to be executable. There are costs to the will that you need to look into, the actual winding up of the estate, the executor cost, and also the last income tax return of the testator. And in terms of accessibility, please make sure that your will is stored in a place where it can be accessible when it is necessary. It will not help to have a very good and tight, well-designed will, and whenever we need it, then we are not able to access it. In that case, you are as good as somebody who doesn't have a will in place. So the taxes associated with the deceased estate, the first one we've highlighted briefly on is the last income tax return of the deceased. Remember, the financial year of the individual runs from the 1st of March to the 28th of February. So if you happen to pass away on the 31st of August, which means now you are liable for income tax from the 1st of March until to the 31st of August, and then everything else will be now taxed on your estate. We also need to look into the deemed disposal of assets. If there happen to be assets that need to be sold before the actual distribution, whatever profit that was made there, you will be liable to pay the capital gain tax on that. And there's an abatement of 3.5 million. This means if your estate is less than or 3.5 million and less, then you don't pay tax on that. Now, important to note, these taxes are not your last income tax. They are not the deemed disposal of asset tax. Your last income tax return, and if there happen to be any capital gain tax there, those they still apply. But on the actual estate, if the estate is less than 3.5 million, then there is no tax to be paid there. However, if your estate is more, any amount that is more than 3.5 million will be taxed anything between 20 to 25%, depending on how much you have on your estate. The more money you have, the more tax you pay. Now, normally, the deceased estate tax duties are paid by the executor. However, if the executor fails to pay those taxes, which means now they will be taxable in the hands of the beneficiaries, which is why it's important to find somebody who is knowledgeable about what they are doing, so as to make sure that your children do not inherit your tax debts or tax implications. Great. There are a few notes that I've compiled for us in terms of your will and the deceased estate. Now, you've got 14 days to submit notice of the passing of the deceased to the court. It is important to appoint a knowledgeable or qualified executor, and appoint also a guardian for your minor children if you can. Try and find somebody that the children are familiar with, somebody who is responsible. If you can avoid placing kids with strangers, please do your best. To the divorcees, when you pass away, your co-parent, whether they were hands-on in the raising of the kids or they cared or whatever, when you pass away, the law recognizes the other party as a guardian for the children. So in your case, you will also want to have a trust that is going to look into the distribution of the minor children's asset to make sure that they are well taken care of from their primary education, secondary education, tertiary education, until they are young adults who are in a position to make well-informed decisions about their money. We don't advise joint wills between spouses, and this is because, number one, once a will is presented upon the death of one spouse, that same will cannot be presented again on the passing of the other or the second spouse. And another thing is, remember, if you draft the will together, which means you both are aware of what is inside the will, which invalidates it, because remember, the beneficiary of the will must not know what is inside the will before the will is presented, right? Yeah, you don't have to appoint a lawyer to draft your will, but if you do appoint a lawyer to draft your will, please make sure this is somebody who is knowledgeable about wills and estates. You don't have to pay for the drafting of the will unless if your will is drafted by a lawyer. If your will is drafted by your financial institute, your tax practitioner, or just anyone who volunteers to assist you, you don't have to pay those people for the actual drafting of the will. You might have to pay them though for the safekeeping of your will until such time when there's a need for it to be presented. That's all I had for you today. I hope we covered everything, and thank you for taking the time to watch this video. I'll see you again next time. Have yourself a good weekend.